Okay, Andrew, and everyone, good morning to you. Want to welcome you to our Employee Handbooks webinar presented by partner Andrew Adams, the practice leader of our Labor and Employment Department. Following his presentation, which should last about 30 minutes, he will take questions via the Q&A feature or through the chat box, both of which are at the very bottom of your screen. Andrew, following that presentation, he will answer as many questions as possible. And if you do want something answered, to just suggest that you get those in as soon as you can. We expect to have a recording of this webinar available and as well as the presentation slides afterward and distributed to you sometime this afternoon. Thank you again for all being here. And Andrew, thank you for taking the time today. The floor is yours.
Thank you, Roger. Welcome all. So first, the last slide we'll have on here will be a Q&A slide. We'll also have some contact information if you want to follow up afterwards with myself, or if you work with the DE attorney already, feel free to reach out to them and connect with me as well. So just want to put that out there. There'll be some contact info on the last slide. But welcome to Employee Handbooks. What you don't know can hurt you. It's a topic that's very near and dear to my heart as the department chair for the labor and employment practice here. It is a really invaluable tool that employers and businesses can put in place for both morale and liability reduction in general. We're not looking at some major policies that you put in place here that will affect day-to-day business, generally speaking, but they are things that you need to have in place to secure and make known to employees to reduce your liability. So with that said, we're going to talk a little bit about the general employee-employer relationship at first, just so we have a little bit of a background understanding there, because there's always some information about the general employment relationship that sometimes businesses don't know. Sometimes you haven't been briefed on before by an attorney. So we'll talk a little bit about employment at will as a concept at first, and then we'll move a little bit into drafting of employee handbooks, form, style, recommendations, some policy recommendations as well. And then we'll get into a section on liability reduction and some recent developments that have happened in the last couple of years. One of the big things that I like my clients and businesses to be cognizant of is that employment, almost more so than many fields of law, is a constantly changing field. So the handbook that you had in place last year may not be up to snuff this year. There are some developments that happen in the fall, some into the new year, and then legal changes that happen almost every year to 6 months to quarterly in some states that occur that require some changes and amendments and revisions to employee handbooks. And they affect almost all policies sometimes. So it's really good idea to be cognizant of, when you draft your employee handbook, have you expanded to other states since then? What states have required policies? If you have an employee handbook, what states are there recommended policies to add onto your handbook? And then has anything changed at the federal level that we might need to amend our handbook? So it's a very important topic. It's a very useful and probably one of your least expensive costs that you can incur to reduce liability for your company. It's generally not expensive to have a handbook review done. And it's one of the best prevention measures that you can have in place, just as a general day-to-day basis moving forward for your company, is an employee handbook. So with that said, we'll get to a little bit of the beginning of the presentation, the employment relationship in general. So the employment relationship between an employee and an employer, the general status of that in every state except for Montana, which has a little bit of a funkier legislative scheme, is employment at will. Now, that being said, employment at will can be changed by actions of employers or documents that are put, or a poorly drafted employee handbook, which we'll talk about in a little bit. So what does that mean? It means that on any given day, an employer or an employee can terminate the employment relationship at any time for any or no reason. There's no real required notice periods on the employee side. There's no required notice periods on the employer side, under the law. And this sets up kind of a misunderstanding sometimes about how the employment relationship works. Because sometimes, depending on what you've read or what you've heard, you might be thinking that, do I need just cause to terminate an employee? Does there have to be a reason? Do I have to give them a reason when I terminate them? And the answer really is no, you don't. And it can be beneficial in some cases to give a good reason if there's something, especially for just cause. But generally, as long as the reason isn't illegal, it isn't preempted by some law or federal or state regulation, it's not, termination for whistleblowing or something of that nature. Generally, the employment relationship can always be terminated at will unless something occurs after the consummation of that relationship to change it. So that is, we're going to talk a little bit about here with handbooks. You can do that with employment agreements if there's a draft in there for a term of employment or thing of that nature. So like I said, the exceptions to that, individual employment agreements that either put a term or a just cause for termination provision in effect, generally for your executives, C-suite, if you have someone developing some very important IP for the company, a lot of situations where you'll have a change in term. A lot of startups will have term employment with their founders or the initial crew that comes in to start up the company because they want some protection on the back end. And that's where you'll see that through those employment agreements. The other agreement that you generally have in place that would change and alter the nature of that would be a collective bargaining agreement. Depending on the negotiations with the union and the CBA, there might be some changes. Generally, there's a just cause requirement. There would be some step and grievance requirements as well, and then some altered probationary periods that would be different from your general company set probationary period, which again does not change termination at will before or after that for private employers. But it does if there's any instance of the CBA that alters that. So it can be altered through contract. Unlawful motive, that's the public policy and adherence to regulations or state law, cannot be terminated for refusing to an employee that refuses to do something that's in violation of OSHA or some other regulation or statute. That would be unlawful motive on the part of the employer, would also alter the employment at will relationship there. You cannot terminate for an unlawful motive. Just cause, direct violation of work rules, violation of safety rules, criminal conduct on the job, things of that nature can be considered termination for just cause. Again, it's not required outside of Montana unless you've altered that by contract, but can be a good idea in situations where you think that there's going to be the potential for liability and you want to insulate the company and provide a reasoning for that and a little bit more support when you do that termination. So a little bit further on just cause, again, generally established by contract. Sometimes, depending on the CBA or the policies in place, if you have a just cause termination policy in your handbook, for example, and you've altered that status, it can include the right to an investigation, substantial evidence of a violation of policy has to be provided by the employer, and sometimes there's progressive discipline steps. Again, most commonly found in collective bargaining agreements with unions. And so just so everybody knows, I know it's clear, pretty much everybody should know this. I know you all do. If you have a CBA in place, you cannot use an employee handbook to circumvent the CBA. The CBA is always going to be the primary document regarding work rules for unionized employees. The handbook will be secondary to that, and it cannot have anything that is not disclaimed in the handbook as being outside the CBA if it conflicts with the CBA. So there's always a little bit of a disclaimer that you want to put in there. If you have a CBA in place, that the CBA takes priority and the handbook does not circumvent it. All right, so setting the tone. We'll get into a little bit in a slide about the actual physical structure of handbooks. There's no one set structure, but the best handbooks, they read easy to an employee. It's a comforting document that you can understand, an employee can interpret without too much guidance, and it flows well. It doesn't use any kind of contractual language. We'll talk a little bit about that as well. Again, not generally required, but highly recommended for employers, because if you're not required to have it, but if you do have it, there's certain things you can put in place that can protect you from liability. And we'll talk a little bit about that as well. One of the major things you want it to be is not a contract, so you don't have contractual terms. You may have a policy about confidential information or information covered by HIPAA and things of that nature, but you don't want to have these long contractual provisions, a handbook that has an arbitration agreement in it, or a handbook that has a full confidentiality, an IP assignment in it. Those are going to lean more towards creating a contract with your employee handbook which then can have repercussions such as requiring you to follow, a step-by-step disciplinary policy instead of having discretion on the side of the employer, which can really, pigeonhole you when you're looking at disciplining an employee that you think should be terminated. But because you've created somewhat of a contract and you're making them follow certain provisions, you're going to have to be required to follow certain provisions as well. And we've seen that play out in the court sometimes. So you have to be careful with that and what you're actually including in the handbook. State requirements, there's a good place to store state required policies. So certain states, not all states, but there are certain states that have certain required policies. And those have to be maintained somewhere. So the best place, for an employee generally is to be included in the handbook. So, one of the best examples of this is the New York HERO Act, passed in the last couple of years, requires basically a COVID protocol with, everything from employer response to remote work to facilities maintenance and the travel of the ventilation system if you're in control of the physical plan of the employer. So you're required to maintain that policy under law in New York if you're operating in New York. And the best place to put that is the employee handbook, because then the employee has signed off. They understand it's in there. And even if they don't, they're required to read the handbook and sign off in the handbook. So they're signing that they've received that policy and that they should have reviewed that policy. Pitfalls that can occur. South Carolina is our big one. There's a back and forth about how conclusive this is in the courts, but South Carolina, for example, has an at-will disclaimer rule, which requires an at-will disclaimer on the front page of any kind of employment agreement or contract with an employee, to be interpreted to include employee handbooks as well. So there's a very specific disclaimer, and there's a very specific way it has to be typed. So there are some pitfalls if you don't include things like that in your handbook, where they can be perceived as altering the at-will nature of the employment relationship. While that can be true in some circumstances, it really depends on the content of the employee handbook as well. So beyond those little pieces, they look at the handbook as a whole. So it's a really good idea to review your handbook, especially if you're advancing into new states. This is what I was talking about when I talk about introductions. And so there's some very famous handbooks that are out there and available for review online. The Valve Employee Handbook is one of the most famous because it's bound like a book and literally walks employees through scenarios in the handbook. So Valve walks employees through their first day. They walk through employees how to handle projects, how to pick up work, company culture on what managers and supervisors and team supervisors expect of work projects and things like that. Who to contact if you need help navigating their systems. So it really feeds into company culture, and that's the culture that they've established. So they wanted that to come through in their employee handbook. Similarly, the Trello employee handbook, you're looking at, a more digital focused company. You have an employee handbook it's not bound. It's not, a paper handbook. It's literally, a collection online of drop-down menus that pop up with policies. And then they kind of build in company culture through some things happening at Trello headquarters, employee lunches, biking to work, some pet pictures and family pictures. And they build in all that company culture while you're reviewing policies. You open the disciplinary policy, but before you see that, you see a bunch of happy employees at lunch, you see, employee pets. So you're really kind of building in, the culture that you want in the company through the employee handbook. So just wanted to show you some very famous examples of employee handbooks that are done in a different fashion. But you'll see they still have all those, policies that you're required to have and policies that you want to have to give notice of: sick leave, holidays, jury duty, unpaid time off, things of that nature, parental leave. But they're just intermixed with some kind of happiness company culture as well. So a little bit about proper drafting, and we'll give you some recommended policies, talk a little bit about it. We won't give you too much of the secret sauce, but we'll set you up with some good policies, and then we'll talk about a little bit of policies to reduce liability as well. So handbook drafting 101. Use plain language. You don't want it to sound overly legal. You don't want it to sound contractual in nature. You don't want employees to be intimidated by the language that you use. Because part of it is having accessible policies that employees understand and know how to navigate. so that you can reduce your liability. We'll talk a little bit about sexual harassment policies, anti-harassment policies. That's where that really comes into play. You want a policy that an employee understands, that they know they can navigate, they know who to go to, where do I file a complaint, how's the complaint process work, how's the investigation process work, what if I'm not satisfied, who can I go to next, things of that nature. It needs to explained out, as well as sometimes you include definitions for terms and things like that. If you think something's going to be a little bit more confusing as well, because you always want it to be clear, concise, and again, non-contractual. So we don't need those kind of fancy Latin terms that sometimes lawyers like I might put into a document. A little bit more general language. So when you're drafting policies, what you also want to do with that language is allow for some company discretion. So you don't want an exhaustive list of things. Discipline includes infractions such as, and then you list them all out. You want to say including but not limited to, such as, is not limited to the following, things like that, because you don't want an exhaustive list and then it says, X through Z warrants discipline, but outside of that, we don't really establish anything. So you want to have a little bit of discretion in that. Same thing with discretionary, generally with disciplinary policies, you want to have disclaimers in there that talk about the employer retaining discretion to move up and down the disciplinary scheme depending on the nature of the infraction. So you never, like I said, you never want to pigeonhole yourself into one response when everything should be as kind of a sliding scale on your end. Again, no contractual terms, full confidentiality IP agreements inside the handbook. Be careful of limiting language regarding discipline and decision making. Again, you want to have that sliding scale of discipline depending on the nature of the infraction and the company response. An example of a policy that is always recommended to start the handbook off is your equal employment opportunity statement. One of the things about these is they vary state to state. They also vary depending on the year federally. We had some case law come out that added sexual orientation to a protection, as well as your other kind of general Title VII and age discrimination protections. So these they change depending on where your business operations are located. It's very important not only for the communication of company culture, it's also one of the main things that we provide in answers to charges of discrimination before the EEOC and local fair employment practices agencies. We always include things like, this is a EEO statement is what it's generally called, as well as, here's our sexual harassment, our other harassment policy. The employer has put these in place. We do enforce them. But it's also good to know for the company in general too. So when you're drafting your EEO statement, you go and you're going to look at, what are protected classes at the federal level, at the state level, and then sometimes at the local level, because local municipal ordinances will also add protected classes. So depending where you're physically located, there may be additional protected classes. So what that means is sometimes in the hiring process that comes into play, because you're looking at hiring, and there are protected classes for New York City, for example, which added height and weight. Some states have marital status. Some locations, I believe DC has, homeless status. Some of those are protected in employment. So, factors that you have to shape in your employment applications, or, deal with not having maybe an address and having to work around that, figure out, PO box and things like that, depending on the jurisdiction and requirements of the employer. Sometimes some of these things are going to come into play, and you can't really force an employee to provide information outside of that if there's a protected status in that locale. So some things may come up that are good to know that you may learn by drafting your EEO statement for your handbook. Another one of our big required policies that you want in every handbook, also recommended on the signature page of the handbook. One of the most vital elements is, you having them sign an acknowledgement they have read, understand, and have had the opportunity to ask questions about the handbook. So one of the big pieces there is the at-will disclaimer. So the at-will disclaimer, crafted similar to what we have here, is just an acknowledgement that the handbook's not a contract. It does not alter the at-will nature of the employment relationship. It reinforces that it's not a guarantee of employment for any period of time. We might add additional language around probationary periods that talks about that as well. But one of the biggest things to have in there is to make sure you have your at-will disclaimer, both somewhere at the beginning of the handbook, somewhere in the middle, if required, a smaller sentence about it, like in probationary periods, and then at the end in the signed acknowledgement as well. All right. Some required policies, we say required because in certain circumstances you are required to have them, not in all. For example, for federal contractors, certain federal contractors covered by federal contracts are required to have a drug-free workplace policy and a pay transparency policy. Federal requirements under different acts required to have the policies. The best place for that is in your employee handbook. Similar to that, if you're an FMLA covered employer, which we'll talk about in a second, you want to be able to have an easily available FMLA policy that explains specifically who qualifies and how to move forward with requesting that type of leave with your employer. Massachusetts has a couple of required policies that you're required to maintain if you meet certain employment thresholds. And then just generally, so the harassment policy, the Massachusetts Commission Against Discrimination has a model policy that they issue. You can see it on their website, you can pull it, you can look at it, and it's kind of like the model policy that you see in New York and California as well, very similar on how they work through that policy. There's Short-Term Leave Act, Small Necessities Leave Act is what it's called in Massachusetts. Domestic violence requires a policy as well for employers at certain thresholds. Data security and earned sick time are the best policies to have in your employee handbook because you're required to have those policies available to the employees. New York City similarly has sexual harassment required policy and annual training and refreshers. And the HERO Act, which we just talked about a couple slides back, required policy to have in New York State. Same thing similar with South Carolina, the at-will disclaimer that we discussed a little bit as well. So liability, the biggest part of our presentation here, reducing liability, what can we put in place? What can we do? And why? So policies for liability reduction, again, handbook's probably the best place to have these policies. Like New York City, your required sexual harassment training policy, general anti-harassment policies, they reduce liability. We're able to use them in defensive discrimination charges. We're able to use them in federal court under what's called the Farragher-Eller defense, we'll talk about in a second. And then there's some states that have additional liability reduction statutes, like Tennessee, for example, has an anti-bullying statute. It used to only cover government employees, but it's been now enhanced to cover private employment as well. And it's an affirmative defense for employers to use if they're being sued under those kind of statutes for bullying and hostile work environment. Tennessee is the anti-bullying policy affirmative defense by having that policy in place in your handbook. And then enforcing that policy. Same thing, it's a great place to have your relationships policy, no tolerance on supervisor, direct employee relationships and things of that nature, company required disclosure or response moving parties, things like that to expound upon relationships. Also a good place to hold that policy. All right, some of the big ones, accommodation policies. So under the ADA, which covers employers with 15 or more employees for accommodation, some states have different state laws that only require one employee. So you could be cognizant of your state law as well. What you want to have is a policy that accomplishes a couple of things. It demonstrates your commitment to compliance by being there, being presented to employees, being out in the world. And it's educating and informing them of your process for requesting a regional accommodation and how that interactive dialogue works. The common issues we see with ADA policies, cliff leave policies. You can request a leave of absence, but it can only be for 3 months, 12 weeks, 20 weeks. Under the ADA, you can't have a cliff leave policy. It's going to be deemed a per se violation. ADA requires interactive dialogue with employees, so you want to always leave it a little bit open. You're not required to give, a leave with no end date, but you are required to discuss how you can accommodate employees, and if an extension on the end of an already extended leave is a potential accommodation, you are required to discuss that with the employee if you're covered by the ADA. So cliff leave policies are always a common issue we see. 100% recovery requirements, also a common issue that we see. You have to be 100% recovered before you return to work. What we want to see is, can they return to work? Can we offer reasonable accommodations to facilitate that return to work, even if they're not 100% recovered from that condition, but they can return in some capacity. So you never want to have a 100% recovery requirement. A failure to engage in interactive dialogue. We see that sometimes, again, with cliff leaves or the 100% recovery requirements where you're not engaging with an employee, seeing if there's something that you can put in place to facilitate that return. And not align with personal leave of absence policies. So you don't want to have a different policy for a personal leave of absence versus an accommodation. Employee A with no disability can request an open-ended leave, but under the ADA, if you're requesting an accommodation as leave, it can only be 2 months. You want them to line up with how they're both operated. So there's no claim that, employees without disabilities are treated differently than those with disabilities. Sexual and other harassment, another big one. Model policies in Massachusetts and New York. Some general policy questions with those that you want to ask yourself about your policy that you have in place or one that you're drafting. Does the policy prohibit harassment based on other protected characteristics in addition to sexual harassment? So you want a sexual harassment, but you also want a harassment based on any kind of protected characteristic, hostile work environment in general as well, so that you're including both ends of it, because it's going to help you out in case you're ever in front of the EEOC. Is it distributed on an annual basis? Now, it's required in New York, and it's recommended in other states to just redistribute that on an annual basis and have an employee sign off on that as well. So is there a signed acknowledgement of the receipt of the policy, the review of it, opportunity to ask questions about the policy as well? And does the company get a signed acknowledgement every year? Again, required in some states, not in others, but best practice is to reissue at least that policy, if not the whole employee handbook, for a sign off every year and review. Some aspects that we want to see in those policies as well: zero tolerance for harassment, a definition of what harassment is. So for sexual harassment, quid pro quo, this for that. Is it, your general supervisory sexual harassment? I'll give you a raise if you do X. Those kind of definitions are all built into the model policies, which you'll see, but you want to make sure that you're defining it out so employees are understanding what the company perceives as harassment under the policy. Provide internal reporting mechanisms. If there's an issue with your manager, go see next step up. If that's to the executive level, to the C-suite, to HR, to the CHRO, what is the complaint mechanism process, and what is that process if you have to skip one step because of the actual incident? Explain the investigative process. You never want to promise full confidentiality because you can't guarantee that. There are situations which require a disclosure or require some notification of some sort. So you can't always promise full confidentiality. You want to explain that the company will keep things confidential as best they can, but this is the process that we use. And then you want to have an anti-retaliation provision as well. The fair girl defense gets into that. It's basically a defense that you can use in court if you have a sexual harassment policy / hostile work environment policy in place, and the employee didn't make use of that. So there's harassment from other employees based on sex, but also has been extended to protected characteristics as well. You didn't take any action against the employee because you didn't know anything happened. So how could you? So you want to make sure that there's no negative action taken towards the employee. You issued a policy and a procedure, and employees were aware of that. So that's your exercising reasonable care to prevent that. And then the employee did not take advantage of that at all. Those are the kind of 3 steps that you have in place that having a sexual harassment or other harassment policy provides you when you need to defend yourself in court. FLSA safe harbor policy. This is for exempt employees. And with any exempt employees, there are some required and permitted deductions under law, but you generally can't deduct from the salary of an exempt employee for partial day absences or non-availability of work on the employer's side. Other threshold pieces: they must have exempt duties and be compensated on a salary basis of at least $684 a week for most scenarios. The safe harbor policy defense is what we call an FLSA safe harbor policy in the handbook. Has a clearly communicated policy prohibiting improper deductions from pay, a complaint mechanism built in. Then the employee has to come in, reimburse the employee in the next payroll cycle or as quickly as possible, and a good faith commitment on the employer's side to compliance. And that's to protect you from an employee saying, okay, they make deductions, so I'm not really exempt. So now I'm going to sue them for 2 to 3 years of back overtime based on my executive salary as an hourly rate. One of the biggest things that you can do to protect yourself from overtime claims with exempt employees: things can accidentally happen. As long as there's a clear policy and a correction mechanism in place, you can protect yourself in those scenarios. Family medical leave, very rare, but it does happen, what's called FMLA estoppel. And with an FMLA covered employer, it's an employee that's worked for the company for at least 12 months, does not always need to be consecutive. 1,250 hours in the last 12 months, and employed at a work site with 50 or more employees within a 75-mile radius. You need to explicitly explain that if it's going to be in your policy. For example, if you leave out one of those metrics and you say this is why you qualify, an employee who's otherwise denied FMLA leave because they really don't qualify based on that prong could bring a claim for FMLA estoppel in federal court. It's happened. I've been party to those cases before. And just drafting errors in employee handbooks can give rise to that too. So you want to make sure it's clearly covered and you're not accidentally creating a policy that you're not covered by. IT policies, won't get too far into it, but the biggest piece of an IT policies is that you want to make sure that you've clearly communicated what's being monitored and what is not considered company communication. So you're saying, everything that goes through our networks, every email you send, every communication you send, it's not privileged. It's going to be reviewed by the company. It's company property. All of those communications are subject to monitoring, because some cases have arisen lately where you're looking at, there's no policy about it. So employees think they have some privacy on those communications. And it's come up in a couple of court cases where, employees have raised privilege on those communications and employers weren't able to introduce some otherwise very damning evidence against another party because someone's now invoked spousal privilege on communications that were clearly through company means, but the company didn't communicate that level of monitoring. So the last piece we're going to talk about before we get to the Q&A is the constantly changing and evolving nature of employment law and labor law. So we're going to talk about the NLRB. Now, the National Labor Relations Board, many employers think that it doesn't apply to them because they don't have a unionized company. That is not really the case. The NLRB will bring forward what we call unfair labor practice charges based on NLRB regulations, NLRB decisions against non-unionized employers. So no matter if you're unionized or not, you do have to comply with the current status of the board. The board constantly changes. It's very political in nature. So every 4 to 8 years, you're going to see a little bit of different policy, a little bit of a different approach. One of the biggest things that's happened lately is it's called the Stericycle decision, which has created a new standard for employer rules, especially handbook rules. And instead of using the old standard, which is a little bit more of a reasonable standard from the perspective of the employer and the employee, what the Stericycle standard does is it looks at a rule and says, does this have a reasonable tendency to chill employees from exercising their Section 7 rights and the rights to discuss wages and workplace conditions, things of that nature, and collectively bargain. So what it does is it looks at that from an employee's perspective who's economically dependent on the company. Would they, deem that to prohibit them from exercising their full rights? A lot more employee friendly than it was in the past. There's a little bit of ability for an employer to rebut that with legitimate and substantial business interest that you can't advance through a more narrow rule, but it came out in August of last year. It's very important to review employee handbooks for any kind of policies talking about employee speech, anything about non-disparagement, things of that nature. That's another decision that came from the NLRB lately. Non-disparagement policies, especially for non-executive staff, non-supervisory staff, should be reviewed because there's now a new knowingly maliciously untrue standard as opposed to kind of the older standard, which was a little bit wider. So a lot of these things happen, they change on the annual basis, and you have to make sure to go back and review for compliance. Even if you're not unionized, you have to be cognizant and aware of what's happening at the NLRB as well. Some of the best things that you can have in place is when you're having a confidentiality policy or something that talks about use of social media, that you're disclaiming that this is not intended to restrict any of your Section 7 rights to concerted activities. We're not saying you can't talk about wages. We're not saying you can't talk about, OSHA or workplace conditions. It's not intended to prohibit that. It's not 100%, going to protect you in those situations, but it's a disclaimer to have to say, listen, we communicated that they were still allowed to communicate this. We're just talking about our confidential IP. So those kind of things to have in mind when you're looking at these kind of policies as well. Some drafting considerations when you're looking at a unionized workforce, when you're reviewing an employee now, clearly stating policy purposes. It's good to have that purpose. This is very important to our company for X, Y, and Z. Identifying specific prohibitions where you can clearly state those. when it comes to these kind of just speech that we're talking about here, not just generally. And then including those disclaimers of non-prohibited activity if relevant to the policy. Again, you want to make sure this is consistently enforced if you have a unionized workforce amongst the unionized workforce under the CBA and the non-unionized workforce, so that there's no variance in how they're being enforced there. Common issues we see here: targeted non-solicitation policies against just union solicitation, but not other forms of solicitation, Girl Scout cookies, things of that nature. And the timing of policy revisions, you don't want it to be right before you're hearing about a union drive either. So a little bit timing comes into play as well with those considerations. All right, and I know I went over my side a little bit, but I want to move on to the Q&A if we can. See what's in the queue here.
Yes, Andrew, to this point, we do not have any questions, but for participants who have yet to do that, please know that you are able to utilize the Q&A function of this as well as the chat. Either one will do. But Andrew, while we have any of those come through, I do have some questions for you. And
Of course.
the first one being, can you just share from your experience where a properly drafted handbook proved to be very valuable for a client?
Yeah, so I could tell you almost anytime I'm in front of the Equal Employment Opportunity Commission, and that's where, if you haven't experienced before, if an employee files a charge of discrimination, which is the claim that it's free to file them, so a disgruntled employee can go over the EEOC or your local Fair Employment Practices Agency and file a charge of discrimination for free, and they facilitate that. So there's no hurdle to that. One of the most important things that I can do if there's a claim of sexual harassment, for example, is in our answer, we're going to lay out your sexual harassment policy, your EEO statement, and then I'm going to go through step by step on how the company followed that policy as it applied. And generally, when you see a lot of compliance with those kind of requirements for going through the policy, we did X, Y, and Z, we fixed the situation, you're going to see dismissals in the EEOC side. I've had it dozens of times where the EEOC will dismiss that outright. And because it's a employee bringing it on their own behalf, generally a lot of these are brought without counsel. That's where it ends, and it doesn't move on to costly litigation in the state or federal court. You can resolve things at the EEOC level with a very solid response. So I've seen it reduce liability by tens to hundreds of thousands of dollars by resolving complaints at the administrative agency by being able to lay out all the policy implications and how the company followed that specifically. So it's very helpful when we're looking at discrimination claims.
Understood. Okay. And then on the flip side, can you share where a poorly drafted handbook had proved detrimental to a client?
Sure. So when we're looking at things, like I said, FMLA estoppel, I partied to a case one time where one of the parties had an FMLA policy, and it had everything except for the exclusion for the number of employees in a workplace. And the company had granted FMLA leave to individuals before under the policy, not knowing that they didn't qualify. They didn't have 50 employees. So because they had granted it in the past, because it wasn't a policy that was drafted correctly and didn't have all the requirements put in place, an employee that was denied FMLA, once they went to their attorney and said, oh yeah, you guys aren't subject to that law, that first employee to get rejected brought a claim, ended up settling for between $15,000 and $20,000. So it was a $15,000 and $20,000 drafting mistake in a handbook that existed prior to being reviewed. So they brought under what this theory was called the FMLA estoppel theory, the federal claim, and they were able to get a settlement of $15,000 to $20,000. So a $1,500 to $2,000 handbook review could have prevented that $20,000 settlement plus attorney fees.
Understood. Okay. Next question here. Can you explain the process of how you approach updates to a handbook for clients?
Of course. So, a couple of things we do is we're going to review the whole handbook. We're going to look through all the existing policies. First off, we'll do a review, see what policies are in there, what policies we recommend to be added. And then we'll go back, go through the existing policies and look at what needs to be updated. If there's something that we highlight that we think needs a revision, we'll provide commentary for every single change that we make throughout the document so that it's kind of a growing and learning document that you can understand why the changes were made, what's changing in the law. And then we add in our recommended policies and then newer policies that have just been added either by regulation or statute, explain the nature and background of those policies as well. Then we provide that document as a clean version and then one as a red line version, going through and commenting on all those policies and revisions. And then we generally set up a follow-up call once the client has reviewed, and we walk through the entire process with them and every policy implementation, and then any reasons that they have questions about any of those policies we might discuss as well.
Understood. Okay. And we know that a handbook should not be collecting dust. So how often should clients or how, employers should be looking to update their handbook?
So we generally recommend it on an annual basis, once a year, if possible, if financially possible for you. Other than that, it should at least be biannual at the most extreme level, because like I said, a lot of these statutes do pass on an annual basis. There are new federal statutes, state regulations, state statutes coming into play every single year, and decisions coming out of the courts and LRB. So the best way to do it is on at least an annual basis. Like I said, two at the most. But then you might miss something in that interim.
Understood. And yes, directing your attention, Andrew, to the chat box, we do have a question from Lisa O'Donnell.
Yep. All right. So the question is, when an employer doesn't meet the requirements of FMLA but wishes to draft a leave policy similar to language of FMLA, is that a concern? Could they remove the reference to FMLA but mirror the language? So I would make a separate policy in that situation, which is more of a personal/medical leave policy when you're not covered by those items. Again, understanding that a state law may come into play that does covers a lot of those standards, like Massachusetts has the Paid Family Medical Leave Act, similar to New York, Connecticut, California has different iterations of that. But you can craft a personal/medical leave policy that allows you to have a little more discretion on the employer side. FMLA is very strict language that you don't want to have to be required to follow if not fully necessary. So you can provide the same kind of, we will grant the medical leave of absence and give you job protection when you return, for a period of time, and we'll work with you and things like that. But you can draft a leave of absence policy that kind of mimics it, but doesn't mirror it, because you don't want to mirror the stringent language of the FMLA too.
Okay.
I think we have another.
Yeah. And then finally, just one last question for me here, Andrew. In terms of go-to sources that employers should be looking to for the latest information on, on their state or business, can you make some recommendations?
Well, always us. I was going to plug the DE Insights. We do issue them as frequently as can in the employment updates, at least on a quarterly basis as well. A lot of state agencies, departments of labor, also are great resources for new laws that have come out. At the federal level, the EEOC has a lot of great guidance, as well as the Department of Labor. So those are always good resources. You want it to be a governmental resource if you're not getting it directly from your attorney, or from one of our DE Insights. Employment law, we do at least quarterly, if not more frequently as well. I do one more question up here, Roger, and it's asking about the most common type of litigation that an employee pursues that could have been avoided by a handbook. Generally, like I said, the best one to protect against is improper deductions. So that exemption policy where we think that there's an exemption being waived because of it, or sometimes meal break policies. So meal break policies are another important one to have that clearly lines up that, employees in certain states like Massachusetts, for example, are required to take their meal break if they're not being paid for that time. They're given that meal break and they cannot waive it. They cannot choose to work through it. If they're entitled to a meal break, they are taking that meal break. It is our policy to discipline you if you do not take your appropriate meal break, and you need an exemption that you've requested your meal break every time that you skip it in Massachusetts, and you want to have a clear policy that outlines that. I've seen a lot of meal break litigation and complaints to the AG's office in Massachusetts, because that's who it goes through. The Attorney General up there, as far as meal break policies and any violations for that. So that's one of the big ones that I see, like on a state specific basis, is a meal break policy violation, and other kind of break policy, and clocking in, donning, doffing policies too. A policy that says that you have to come to work, get in the required work gear that we require you to wear, such as in a meat processing facility, and then clock in, would be a violation. So you want to have a clock in and then get dressed policy, and certain situations were required to don and doff by company policy. That's another big one that can be avoided by a properly drafted policy. Oh, Roger, I think you're muted here.
Good. Thank you, Andrew. Apologies for that. Yeah, that has all the questions. And just a reminder to all participants, we expect to have the recording of this webinar as well as presentation slides available to you later today. So be on the lookout for that. Otherwise, as this final slide notes, Andrew is reachable via his email there, aadams@darroweverett.com, as well as at the phone number listed. And yeah, certainly want to appreciate or just thank you for taking the time, Andrew. Thank you, all participants, for joining us. Certainly appreciate your time and have a great Tuesday.